committee today, but I can't. What'd you say? Does he get it too? Oh, Bob, where are our treats, by the way? Oh.
Madam Chair.
I can't second that. What? Okay, next year, I think we'll all be convening here, I hope, and so. It is, this is it. You could deliver. It's like Grubhub on the floor. Bob will be delivering us stuff, so, okay. Okay, anyway, thank you everyone for being here. Our agenda today deals with working some bills and getting them out of our committee. And welcome to Representative Berquist. We appreciate you filling in for Representative Ward today. Yes, how many years did you serve on Judiciary? Yeah, okay, thank you. Right, thank you. Well, good to have you with us. Okay, committee, there's one thing we're gonna do first, and it was something that kind of came up just today. And if you recall, we had Senate Bill 138, which was about search warrants and different things. We put it into Senate Bill 157, so we do have a committee shell. So I'm going to open up Senate Bill 138, and I'm going to ask you to put the contents of our scrap metal bill into that bill because it kind of hit a roadblock in the Senate. And it was a good bill because, you know, we didn't all love it at first, but we took out everything that was not, you know, that people did not agree on, and we ended up with pretty much one paragraph that all the stakeholders, the scrap metal dealers, the different people, law enforcement agreed on. And so I would be sad if that just went away and we weren't able to do something with it this year. And I don't know exactly, we may just leave it below the line, but whatever we do, we've got it there in case we are able to do something with it in conference committee. So questions, Representative Osmond.
Thank you very much, Madam Chair. Sorry. We're talking about House Bill 2349.
Just making sure. Yes, House Bill 2349 that we amended in committee and passed out, and then it went on the House floor and it passed, I think it was like 123-1 or something right around that. 120-3. Okay, so there were 3 no votes, but yeah. So Representative Bohai.
Thank you, Madam Chair. I can't remember, did the Senate work any sort of scrap metal bill this year?
No, they just didn't.
Okay, that's all. Thank you.
Did not get to it. Mm-hmm. So I'm not saying I don't know exactly what might happen to it, but by us doing this, it's in a Senate bill. It will be below the line. We'll just kind of see if we can see what we might do with it because it was so positive in our committee and on the floor. We have a position on it, and I hate to lose that. Representative Vaughn? Well, yeah, Representative Vaughn.
Thank you, Madam Chair. We were just going for, what was the shell number?
138. Shell 138, yep. So it would become a House substitute for Senate Bill 138 is the way it would work. So what other questions or comments do you have about that? Representative Carmichael.
Thank you, Madam Chair. Much to some people's surprise, I will support this idea because it burns up a shell, and so it won't be available for Republican leadership to use for more nefarious purposes. Thank you.
Whatever reason you want to vote yes, I'll take it. So, okay. All right. Do we have a motion? Representative Curtis. Questions?
Well, I was going to make a motion, but I'll just say I support this because, you know, we should talk about scrap metal every year. It should never go away. It should just keep coming back.
I'd entertain a motion if you're interested, but
You're out the wording on the motion. Okay. I move that the committee pass out favorably House, oh, no, wait. I have to like put, I have to amend
Put the language of House Bill.
uh,
Okay.
2349. Okay, so I move that we put the language from House Bill 2349 into Senate Bill 138, making it House sub for Senate Bill 138.
Perfect. Do we have a second? Representative Lewis seconds. Any other discussion? Representative Carmichael.
Thank you, Madam. Just to make sure we have a clear record, I think the intent of the motion is to remove the contents of Senate Bill 138 and replace them with the contents of Senate Bill 2349, not have both bills' language, otherwise known as a gut and go.
Yep. That's interesting. I was thinking 138 was already empty because we had taken those contents and put them somewhere else, but I guess we duplicate. Is that true? Just for a future? Okay. Okay, all right. Okay, thank you. Yeah, thanks for the clarification. Okay, any other discussion? Okay, all those in favor of, or would you like to close on your motion?
Sure, I'll close and just move the motion as restated by Representative Carmichael.
And that's fine with the second also, that you do it that way. Yep, okay, great. You've heard the motion. All those in favor say aye. Opposed, no. The ayes have it. And so now we've amended 138. So now we need to pass Senate Bill 138 favorably for passage. Representative Williams.
Thank you, Madam Chair. I move that we pass out House sub for Senate Bill 138 as amended favorably for passage.
Do we have a second? Representative Curtis seconds. You're welcome. Okay, any discussion on that one? All those in favor of passing out House sub for Senate Bill 138 favorably for passage as amended, say aye. Opposed, no. Okay, thank you, committee, for that little piece of just making sure we get that done. Okay, we will now look at Senate Bill 204. And we heard that on March the 11th. And I'll ask the revisor to give us a little update on what Senate Bill 204 was about.
Thank you, Madam Chair. Jason Thompson, Revisor's Office. So this is Senate Bill 204, requiring case and warrant information to be sealed in criminal and juvenile offender cases. It amends the statute up in the civil code about sealing or redacting court records to provide that all subpoenas in a criminal case or a case pursuant to the Juvenile Justice Code will be sealed by the court, as well as all cases in which an arrest warrant is being sought will also be sealed.
Okay, thank you. Committee, what discussion do we have? Do we have any, or do we have any amendments? Representative Williams.
Thank you, Madam Chair. I have an amendment.
And we'll let Jason grab those, and you want to
Yeah, I can kind of
let
explain.
people, you want to explain it
Yeah.
as they're passing it out?
So if you remember on this amendment, the proponents talked about clarifying language to include the return of service envelopes for the subpoenas to also be included to help alleviate the concerns of the neutral testimony.
Does anyone have any questions for the carrier, the bringer of the amendment? Representative Boheim.
Did the proponents have any problems with your amendment?
No, they asked for it.
They agree to it.
They
yeah.
agreed to it.
Any other questions for Representative Williams? Would you like to move your motion?
Thank you, Madam Chair. I move that we amend Senate Bill 204.
Do we have a second for that? Representative Bohai seconds. Okay, any other discussion on this amendment to Senate Bill 204? You had a minute to look at it. Okay, seeing none, Representative, would you like to close?
I close and move my motion.
Committee, you've heard the motion to amend Senate Bill 204. All those in favor say aye. Opposed, no. Okay, so it will be amended, and now we're on the base bill 204 as amended. Do we have any other amendments or any other discussion on 204? Representative Williams.
Thank you, Madam Chair. I move that we pass out Senate Bill 204 as amended favorably for passage.
Do we have a second? Representative Schreiber seconds. Any other discussion on Senate Bill 204? Okay, seeing none, committee, you've heard the motion to pass Senate Bill 204 favorably for passage as amended. All those in favor say aye. Opposed, no. The ayes have it. And we will pass Senate Bill 204 favorably, and Representative Carmichael would like his yes vote.
Thank you, Madam Chair.
In the minutes, please. Thank you. Okay, committee, we will now look at Senate Bill 241. We heard that on February 27th. It is the bill, well, I'll let Jason give us a reminder about what that's about.
Thank you again, Madam Chair. Jason Thompson, Revisor's Office. Senate Bill 241 is the bill that provides restrictive covenants in certain contracts are enforceable and not considered a restraint of trade if they meet certain requirements. You may recall that this is the one that has several paragraphs describing different restrictive covenants and a conclusive presumption that they are valid if they have certain content and don't continue for more than 4 years in a couple of examples or more than 2 years in a couple of others.
Okay, discussion or amendments, Representative Lewis.
Thank you, Madam Chair. So since we heard the bill, I've worked with Representative Carmichael and some of the stakeholders on the bill, and I think I can represent that everybody's now on board with the bill as we will seek to amend, and I'll explain that. I'll just start by saying that
Should we go ahead and, can we go ahead and pass out the amendment? Is that okay?
that'd be fine.
Okay,
I'm
great.
not going to speak to it immediately, but that would be fine, yes.
Okay.
So
Go ahead, Representative.
when I first saw the bill, I was negatively disposed to it because I have had I've worked in this area and have litigated restrictive covenants. And what my experience tells me is that each case is unique and different, and I was a little bit concerned about the bill as presented, essentially limiting the scope of issues or facts that the court could look to that I thought would be relevant to the inquiry as to whether any particular restrictive covenant was unreasonable, an unreasonable restraint of trade. So with that in mind, I and I think Representative Carmichael and some others involved started working with the proponents, and the amendment that was just passed out is designed, I think, to accommodate some of those concerns that I expressed and to, in some ways, narrow the bill in the sense of not restricting the court's ability to look at different issues and facts. So some of the language I think is more clarifying than anything, but if you look at the page 2, you see the balloon for the purpose of interfering with the employment or ownership relationship of such employees. So going back to the whole sentence, starting on page 1, line 35, It says a covenant, which is just a promise in writing in which an owner agrees. So an owner would be, think of a partnership agreement, I think would be. So there's an owner of a partnership agreement, agrees not to solicit, recruit, induce, persuade, encourage, direct, or otherwise interfere with, directly or indirectly, one or more employees or owners of the business entity for the purpose of interfering, this is the addition or amendment, for the purpose of interfering with the employment or ownership relationship of such employee. So this is saying if you've covenanted or promised not to interfere in this way, the court also has to say that you did that, agreed to that for the purpose of interfering with the ownership agreement. In other words, you promised, I'm sorry, I'm getting confused here. You promised not to solicit if you're doing so for the purpose of interfering with the employment or ownership relationship of such employer or owners. That was just added, I think, to more narrowly define the scope of that agreement not to solicit. And then it goes on to say if that's the case, then it shall be conclusively presumed to be enforceable and not a restraint of trade. If, and this is another condition, if the covenant is between a business entity and owner of the business entity, and the covenant does not continue for more than 4 years following the end of the owner's business relationship. So once again, the fact scenario is you have an owner of a business who decides to leave. He or she has agreed not to solicit other employees or owners. If to do so is to interfere with the employment or ownership relationship. And if that covenant is not for more than 4 years, then it's presumed to be okay, enforceable. So that was, I said, I think that balloon is simply slightly narrowing that restriction. But the most substantial change here is the one at the bottom of page 2, and it's on line 43. And this says, notwithstanding the presumption of enforceability provided in subsections C2 and through C5. And so each of these sections, C2 deals with owners, C5 deals with C3, it deals with owners interfering with customers. C4 deals with employees interfering with other employees, and C5, I believe, is with customers. So each of those deals with a little bit different relationship. But what 7 does, section 7, is it concerns all of those, C2 through C5, and it says, notwithstanding the presumptions set forth in those previous sections, an employee or owner shall be permitted to assert any applicable defense available at law or in equity for court's consideration in a dispute regarding a written covenant. So basically it says there may be presumptions, but if you are an owner or an employee and are being sued, you still have still have all of your defenses. So it's a fairly significant, I'd say, carve out from the presumption, and that's the language that satisfied me, and I think Representative Carmichael, that this is something that preserves, on the one hand, it sets forth presumptions which gives some degree of clarity for businesses and employees and owners entering into these agreements, but it doesn't tie the court's hands, which was my concern when I started looking at the bill. So with that, Madam Chair, I will move my amendment to Senate Bill number 241.
Okay, thank you. Do we have a second? Representative Carmichael seconds. Committee, what questions do you have for the bringer of the amendment? Representative Carmichael.
I assume discussion would be appropriate.
Yes, of course. I mean the same thing.
And I'm
I said
sorry to
that.
step in front of the vice chair on the second on this one, but it's one where if it goes wrong, it's going to bite me. Might as well get me bitten rather than you. If anybody wants to see a case where Carmichael represented somebody and won the battle, but justice wasn't done, take a look at the case of Piper versus Sigmatech before the United States, before the Kansas State Supreme Court, where I tried a case in very similar circumstances to these. My clients dodged the bullet, and probably in retrospect they shouldn't have, but at any rate, Representative Lewis is correct. This bill, as it came to us from the Senate, was seriously flawed, in my opinion, and probably was not necessary. I still feel like it's not truly necessary. There are antitrust provisions that are above my pay grade. But I really appreciate Representative Lewis's work, as well as the work of the chamber and a company that has sponsored other legislation here from the back row, and I see that they're well represented here today. We came to an agreement that probably does no harm. And as Representative Lewis points out, the intention here was to perhaps create certain presumptions statutorily, but at the same time preserve what are known as defenses in equity or at law, which is the current state of the law. I don't want to get any deeper into that. I might also mention that with Representative Lewis's help, we expanded the protections for former employees to also include what's described as owners, but in the context, I think it refers to what would be former owners of a company. Part of what our concern was, there may be people who own a very small interest. Perhaps they've acquired it through what's known as an ESOP, an employee stock ownership plan, or otherwise. And we wanted to afford to them the defenses at equity and in equity and at law. And so with the representative's help, all of those things have been accomplished. Just to step forward just a moment, I think the state of Kansas would get along fine without this legislation, but in view of the improvements made in this amendment, I will likely support the bill as well, but not with a very strong voice. Thank you, Madam Chair, for hearing me out.
Okay, committee, any other questions for concerning the amendment? Okay, seeing none, would you like to close on
Thank
your
you,
amendment?
Madam Chair. I move my amendment.
Thank you. Committee, you've heard the Representative Lewis's amendment to for Senate Bill 241. All those in favor say aye. Opposed, no. Okay, we have the amendment, and now we're on Senate Bill 241. What discussion do we have for that, Representative Lewis? Or if we have a motion?
I was going to move the
Great.
amendment. The bill is amended. There is a
Oh, is there a
Representative
question
Bohai had a
before
question.
that? Okay, Representative Bohai.
I just think we're up to 6 times that they've agreed.
I'm glad somebody's keeping score. I lost score at some point. I mean, it was getting a bit ridiculous.
Yes, definitely. Thank you for that. Representative Barth.
Okay, thank you, Madam Chair. I do not have an amendment or one ready. I actually would have liked to have had an amendment potentially on this bill. I don't think I can fully support it yet, but I want to tell you why. And I don't know if this committee is in favor of this or not, but I don't have a written amendment. I would need the reviser's help on that. I did talk with the folks that brought this bill or were for this bill about my concerns. So as an employee's perspective and working with companies that have non-competes, call it a covenant, call it an NDA, you name it, they all deal with the same type of thing. And I just had some concerns about it, the way it's written on page 2, line 26, where it says, does not continue for more than 2 years following the employee's employment. So I had some questions about that, where it almost makes it seem like it has to be 2 years, where I'd rather have stated something where it was for up to 2 years. And so it's just minor language changes, but that was one area in concern. And then I had a second thing too, so I don't know if you want any discussion on that at all or thoughts.
You are welcome to discuss and say whatever you'd like to say about it.
Okay. That was something I was wanting to change, and if we end up passing it out of the committee, that is something I would want to bring an amendment potentially going forward, if there was some support there on that. The other thing I had was on page 3, which was line 42, where it talks about material contact customer, means any customer or prospective customer that is solicited, produced, or serviced directly or indirectly by the employee or owner. In my line of work, I'm in sales for a living, so prospective customer is pretty vague, and there is no definition that I'm aware of that defines what that means. So if I'm an employer or an employee, like, you could determine that anybody, every business is your prospective client or prospect in the state of Kansas or the United States or the globe. And technically, when employers look at this, it is typically of groups that are in process, have been named groups within something that they're working on. They've actually been calling on them. They've had meetings with them. They've got a proposal extended, something to that extent, which makes them prospective client versus just any and every business could be potentially named. And the reason I bring this up is offering protections to the employees who need to have a job after this job, like they've moved on. So the former employees, like, I don't want it so prohibitive that they can't earn a living, as long as they're not calling on that listed named prospective groups. So those were my concerns of where I was thinking about bringing an amendment. Just with the way things are going, haven't had time to work on it.
Well, and you are certainly welcome to bring an amendment on the floor if we pass this out. We don't do, conceptual amendments in the committee, but Representative Lewis, if you have an answer or would like to
Yeah,
comment.
I'd like to just speak to that. Yeah, I certainly appreciate the issue, which is central to this bill, about the rights of employees. And my concern was, and I think Representative Carmichael's, with the really the small owner, that they need to have the option under fair circumstances to go out and find other employment when that employment ends for whatever reason. That is, we were very cognizant of that problem or issue as we worked with the stakeholders. As to the customer or prospective customer point, so let's look at the entire definition there. Material contact customer means any customer or prospective customer. Okay, that's broad. I agree, prospective customer is very broad, but it's narrowed by the follow-on. That is, so the prospective customer is solicited, produced, or serviced directly or indirectly by the employee or an owner at issue or the customer. So it wouldn't be a prospective customer of the entire business. It would have to be a prospective customer that the owner or the employee, who's in this hypothetical being sued, actually had contact with and had helped to recruit. So it's narrowed by that language on there. It's not going to bar them from soliciting any and all customers that the business prospectively might have been targeting. As far as the dates go, I mean, I think the language is pretty clear that there's a presumption that pertains if, depending upon which of these sections you're talking about, the covenant doesn't go longer than either 2 or 4 years. So and quite frankly, under the language, it could go longer or it could go less. It's just that if you want the presumption, it can't go longer than the 4 or 5, the 2 or 4 years. So on that point, I'm not exactly sure what the issue is. Maybe I just didn't catch it.
Representative Barth.
Thank you, Madam Chair. Just as a follow-up comment, it's for up to 2 years is the language I would prefer, so that it didn't make it sound so definitive that it is 2 years. So employers could write contracts with their employees, covenants, non-competes that says up to 2 years, where I think with the way it's written, if I were to look at this and I was an employer, especially a newer employer who's writing this type of an agreement and was working with a law firm, maybe they're new at doing this as well, that the way it's written today, I would think they put in 24 months versus up to 20, or 1 year. Like, a lot of the non-competes I've signed are 1 year. So that was my point there. And then he brings up some good points on just the perspective. If you feel comfortable that there has been trials or cases where that language is good enough or pretty protective for employees, but the only thing that I would say is directly or indirectly. The indirectly piece of it is probably my biggest concern. So let's take, for example, a normal utilization of someone who's in this industry who has signed a non-compete. They've got a prospect list. Let's say they work with businesses that are, 100 to 200 employees, let's say, in a certain specific industry. And let's say I pull every single business in a certain area that I can focus on, and I put those in my database, and those are in there, but I haven't actually, fully, well, I probably have tried to solicit something, but nothing's ever come of it. Those are the types of concerns where that's truly pretty strict in the legal world. Like I would say that in every one of those businesses, I could not work with going forward if that were the case. And I'm just trying to say this is not just me, this is anybody that is, especially in sales, I would say probably maybe like attorneys, but typically people are in sales who would have name lists of potential prospects. So I know I'm belaboring this, but like this could impact my life, my family, my friends that are all in sales and professions. And so I just want to make sure that we're providing true protections for people because this could be life-changing and career-ending for people.
Thank you. Any other discussion? Representative Carmichael.
Thank you, Madam Chair. Representative Barth raises very good points. And were I not a party to the negotiations that resulted in this compromise, you would hear me today arguing against the bill for the very reasons that the representative describes. And I do believe that her concerns are still valid, despite the language that's been used here, which in my judgment made a bad bill much better. And certainly if the representative brings such an amendment on the floor, I will obviously be compelled to vote. But for the time being, I hope that there is some solace provided by the notwithstanding clause that's on page 2 at line 43. And that rolls back into this entire equation the long, and I'd like to say well-established, but they're not always well-established, doctrines of equity, in other words, what's fair, as well as certain provisions of the law that pre-existed this legislation. And one of those principles in equity is that a non-compete agreement must be reasonable as to its scope. And scope, and people who are truly expert could tell you better, but scope includes the concept that you can't take away somebody's livelihood by precluding them from ever practicing their occupation, their profession again, by saying the world is a prospective client. It used to be we could limit these agreements by geographic scope, but in today's world, the internet is international, and so the concept that you're only limited to Sedgwick County, Kansas, or wherever just doesn't work anymore. So the bottom line is I hope that folks will not dismiss out of hand Representative Barth's concerns, because I think they continue to be real ones. I did my best, and I think others did their best under the circumstances to do the best we could with the work product of the Senate. So that's where I'm at, Madam Chair.
Okay, thank you. Representative Barth.
I'm sorry, this one kind of hits home for me, so appreciate the conversation, Madam Chair. And I will work with anybody that wants to work with me on an amendment for the floor, assuming this comes above the line, and we'll have more time to work on that. So I'll work with Representative Carmichael and anybody else that would like to join me on those amendments and just further clarifying the language. I also just have a little bit concern and maybe a little bit of heartburn about how this conflicts with I don't remember what it was federally, how they basically said on red X on any kind of, non-compete. And this, even though you call it a covenant, it technically, in my mind, is the same exact thing, same thing. So that gives me a little pause. But anyway, I appreciate it. Thank you.
Representative Carmichael.
Yeah, I just want to make sure I don't mislead anybody. I've cut the best deal I could under these circumstances, and I certainly encourage the representative to bring whatever amendments she believes are appropriate, and I'll vote on those amendments. But out of fairness to the people that I've worked with, I'm not going to try to renegotiate the deal I've made, whether it's good, bad, or otherwise. Thank you.
Committee, do you have any other questions or comments on the amendment to Senate Bill 241? Okay, seeing none, would you like to close on your amendment?
I'll close. This is actually on the bill as.
Oh, on the bill. It's already as amended. So sorry. You closed. Okay, committee, we need a second. Representative Williams seconds. Okay, committee, you have heard the motion to pass Senate Bill 241 favorably for passage as amended. All those in favor say aye.
Aye.
Those no? Okay, I believe the ayes have it, and we will pass Senate Bill 241 favorably for passage. Yes, Representative Carmichael is an aye vote. Okay, committee, we're now going to look at Senate Bill 186. And I'll ask Jason to give us a little synopsis of Senate Bill 186.
All right, thank you again, Madam Chair. So this Senate Bill 186 requires probable cause affidavits to be made available to law enforcement agencies prior to the execution of a warrant or summons. Just adds a line that says the affidavits and testimony in support of probable cause will be made available to law enforcement under the Code of Criminal Procedure.
Okay, thank you. Committee, we will open that up for discussion. Excuse me. And I'm going to tell you that we're going to bundle some things here into Senate Bill 186. I'm going to ask you to bundle some things into Senate Bill 186. It would be a crimes, punishment, and criminal procedure. House Bill 2389 is one of the bills that I would like to put into Senate Bill 186. And Jason, remind me, go ahead and tell us about Senate Bill or House Bill 2389.
Thank you, Madam Chair. House Bill 2389 is the one you heard on March 12th, if you're looking for it. This requires certain prior convictions to be considered in determining bond when a person is arrested for certain sex offenses. There's a list of crimes listed in the new subsection in the bill. And if you're charged with one of those crimes, the magistrate who is looking at your bond is required to consider prior convictions of those offenses or comparable out-of-state convictions.
Okay, so what we're going to do is we're going to talk now about House Bill 2389. And do we have any amendments or discussion? Representative Williams.
Thank you, Madam Chair. I have an amendment. So this language, as they pass it out, was worked on between the district attorney, Steve Howe, and the bail's bondsman to kind of address what the intent of the bill originally was. And it is not the language included in the testimony that I read, but I will have Jason explain it, and it's on page 4.
Thank you, Madam Chair. I think everyone has their copy now. So we're adding some new language on page 4. You can see we're redesignating the current proposed edition as a paragraph 1, striking sexual battery from the list of crimes leaving aggravated sexual battery, but striking sexual battery. That's one strike. And then rather than having the magistrate consider prior convictions, there's some strikes around there to say the magistrate shall determine prior convictions of such offenses or comparable out-of-state convictions upon available evidence. So that's the first paragraph. You're charged with one of those crimes, magistrate determines prior convictions based upon available evidence. Paragraph 2 then is added in the big box. If the magistrate determines defendant has a prior conviction of any crime that constitutes a sexually violent crime, as defined in 22-4902, bond shall be at least $750,000, cash or surety, and have at least minimum conditions of no contact with any victims or witnesses, and the magistrate shall place the person under house arrest under subsection A4 of this section, which is one of the dispositions you can have for bond. The second sentence there, such bond shall not be reduced or modified downward unless the magistrate determines by preponderance of the evidence at an evidentiary hearing and makes a written finding on the record that the defendant is not a public safety risk and not a flight risk. And finally, at the evidentiary hearing, there is a presumption that the defendant is both a safety risk and a flight risk. That's it.
Committee, what questions do you have for the bringer of the amendment? Representative Carmichael.
Actually, Madam Chair, my question is for the reviser.
Okay, great.
On the amendment, of
Yep.
course. This sounds like we're setting a minimum bond amount by statute, subject to certain provisos. Do we have other examples of where the legislature has gotten into the business of setting bond? I'm not familiar with the statute where the legislature sets the bond. That's the job of judges. I'm just wondering if we've done that somewhere.
Jason. They're thinking and talking.
Sorry, Madam Chair, we did.
And I can think of a bill about DUI or something there. Yeah, there's something somewhere. Go ahead, please help me.
And Madam Chair, there aren't many. We're familiar with a couple of crimes where there's a specific provision that says bond shall be a minimum of $50,000, for example. One, I believe, was the racketeering, possibly. One was definitely the criminal street gang. One of the drug crimes, I can't remember if it was manufacturing or another, but a few, and they're done in a specific crime, whereas this one is more for a class of crimes. So I guess that would be the distinction, but not unprecedented, I guess, to use that word.
My second question, with your leave, Madam Chair. There's a constitutional requirement that except for certain specified crimes that bond be made available to defendants. Is it constitutionally acceptable, so far as the revisers know, to impose house arrest in view of the prohibition against not setting bond because house arrest is a restraint upon liberty? And accordingly, is it constitutional to say in every case there will be house arrest?
Madam Chair, or in this case, Madam Vice Chair. It's a difficult question for me to give you a clear answer. There are requirements that bail considerations be done on an individualized basis, so that could be a potential issue. There are also potentially a finding in these cases that this particular crime, there is a specific interest in house arrest for public safety reasons, and so that might be the counter argument, and I don't know for sure how a court might find at this point.
And I'm sorry to put the revisers on the spot. I only saw this myself within the hour, so I didn't have a chance to do any research at all on the topic. And criminal law is not my forte.
Any other questions? Representative Carmichael.
I understand that people are absolutely upset and entitled to be upset about people who commit these types of crimes. And maybe in a perfect world, we just lock them up, throw away the key, and they'd never get out again. But that's not allowed under our Constitution. We have to abide by it. And the law has always been that it's a particularized determination as far as what bond, particularly for serious offenses. I mean, there may be a standard bond for jaywalking or something like that, but in serious offenses, the magistrate, i.e. the judge, has to look at the situation in each and every case and make a determination as to what is appropriate. So by way of example, there's a constitutional prohibition against excessive bail. So by way of an example, if God forbid, Donald Trump was charged with one of these sex crimes, $750,000 would be, in my judgment, far insufficient to ensure his appearance because the man, by his own account, is a multi-billionaire. On the other hand, if we were talking about my little brother who lives on disability, $750,000 would undoubtedly be excessive bail because there's no way in the world that somebody living on a disability check is going to be able to make that kind of bail, let alone the premium. So I think we're taking away judges' discretion. I think we're potentially violating the Constitution. But even as importantly, we're steering well outside our lane as the legislature. Judges have their responsibilities and we have ours. We define crimes, we define punishments. But we should not be getting into the business of setting minimum bail when bail is an individualized undertaking based on the facts and circumstances of a particular case, and that's within the province of the court, not the legislature. So I think we're violating the separation of powers doctrine as well. Final comment is, my hat's off to the bail bondsmen. They've had a great year this year, and this just makes it all the better for them. Thank you.
Representative Bergquist.
Yes, ma'am. Just in follow-up with the representative's thoughts and legal perspective, what gives a judge the opportunity to present no bail? Is that all within his own purview? If there's no bail allowed on a case?
Jason, do you have a?
Madam Chair, so generally speaking, the biggest reason is the public safety finding, that public safety requires that the person not be returned and be held awaiting trial. That's the biggest one. There could be others, you're a flight risk from the jurisdiction for any number of reasons. But as the representative mentioned, there is a presumption that you are bailable for all non-capital offenses. And so you have to essentially have a good reason to hold the defendant without bail. And those are the two most common ones I can think of.
And so to follow up, so having a situation with no bail would not be a statutory limit, but it would be a judgment of the court. Is that correct? I'm just comparing that to having a floor for the $750,000. Is there a position where the floor is absolutely no bail?
So, Madam Chair, the only no bail that's guaranteed is established for capital offenses, and that's in the Constitution, actually, not just statute. I think for all other offenses, you at least have the opportunity for the magistrate to consider releasing you on bail, but it can be denied for certain reasons.
Thank you, Madam Chair.
Committee, who has other questions or comments? Representative Barrett.
Just real quick, and the revisor can correct me if I'm wrong. I think I did find under that statute with the definition of sexually violent crime, which includes rape, indecent liberties, aggravated indecent liberties, criminal sodomy, ag criminal sodomy, indecent solicitation, aggravated indecent solicitation, sexual exploitation, aggravated sexual battery, aggravated incest, electronic solicitation, unlawful sexual relations, ag human trafficking, commercial sexual exploitation, promoting the sale of sexual relations, internet trading in child pornography, or ag of the same crime, any conviction or adjudication of an offense that is comparable to a sexually violent crime as defined in the subsection. So, and there's like in conspiracy with any of those offenses as well. So those are kind of the crimes that sounds like we're dealing with.
Okay, thank you. Any other discussion? Representative, would you like to make your motion?
Um, I move that we pass amendment to House Bill 2389.
Do we have a second? Representative Barrett seconds. And then any other discussion on the amendment? Representative Williams.
Thank you, Madam Chair. You know, I thank the representative for sharing some concerns, but I do think, you know, as we're looking at the statute, it is a little bit different, but it isn't unprecedented to address some of these issues. I mean, when we're looking at determining bond on previously convicted sex offenders, these people have a high likelihood to reoffend. And so from a safety aspect for the community is something for the judge to take into consideration. As we heard from proponent testimony on 2389, judges are being more lenient on bail. And so I think in concern for the victim and the community, I think this is good policy for public safety, and I hope the body votes in favor for this.
Any other questions or discussion? And then would you like to close, Representative?
I close and move my motion.
Okay, so committee, what we're doing is at the moment, we're just amending House Bill 2389. And then we'll take up that bill and what we're going to do with it later. So, okay, you closed? Okay, committee, you've heard the motion to amend House Bill 2389. All those in favor say aye. Aye. All opposed, no. The ayes have it, and we have amended House Bill 2389.
Could I have my negative vote recorded on that amendment because of what we're going to bundle together momentarily?
Yep, So Representative Carmichael's a no vote on the amendment. Okay, so now committee, Representative Williams.
Thank you, Madam Chair. I move that we put the contents of House Bill 2389 into Senate Bill 186.
Do we have a second? Representative Bohai seconds. Okay, what discussion do we have on this committee? Representative Carmichael.
Thank you. I think the intention here in this case is not a gut and go, but rather to add the provisions of the bills into, combine them into one bill with the number Senate Bill 186.
Yes, exactly.
I just want to make sure we're clear. Thank you.
And if I understand, the way we do it is section by different section numbers. Is that correct? You would add a section number to Senate Bill 186? Yep.
Yeah, thank you, Madam Chair. So just to clarify, yes, we would just, so section 1 of 186 is amending KSA 22-2302, and then the other bill is amending 22-2802, so it would be section 2 of the bill, and we would just renumber everything after that.
Okay, thank you. Any discussion, any other discussion, committee? Okay, seeing none. Oh, I'm so sorry. Representative Carmichael, didn't see your finger.
That's okay. Thank you. The Lord gave me a voice for a reason. I want to oppose the amendment because I want to vote for Senate Bill 186. I think it's probably an okay, good bill. Frankly, I wanted to vote for 2389 before we amended it. But now, when you bundle them together, it's what I would refer to as a bad bundle. It's one of these situations where members may support one bill and not the other. And so now it's placed the members on the horns of a dilemma. Do I vote in favor of a combined bill where half the bill is good and half the bill is, in my judgment, in violation of the Constitution, and in my judgment, an infringement upon the separation of powers and the principles of judicial discretion and the right of every American to have their case decided based on their individual circumstances, not based upon a presumption? So the best way for me to stop that from happening is to oppose this amendment, and I do.
Any other comments or questions, committee? Seeing none, Representative, you may close.
I close and move my motion.
Okay, committee, you have heard the motion to amend, Senate bill will amend, we're putting the contents of House Bill 2389 into Senate Bill 186, 2389 as amended. All those in favor say aye. Aye. Opposed, no. The ayes have it, and so we will do that.
May I have my no vote on the amendment recorded, please?
Yes, sir.
Thank you, ma'am.
Okay, committee, I now would ask you to look at House Bill 2401, which we heard on March the 12th. And committee, I will remind you, House bills, we're hearing 2 House bills I'm asking you to put into Senate Bill 186. We've put one in, we have one more. The reason for that is because now that they're in a Senate bill, then they're able to be in conference and we can talk about them, we can get them figured out. If we just passed a House bill out today, we wouldn't be able to do anything with it. So at least this way, we can talk about it. We can possibly change some things, make it better. But that's the reason for doing this, is because we have 2 House bills that were still kind of sitting out there that we had not done anything with yet. And so, so looking at House Bill 2401, do we have any discussion on just on House Bill 2401? Any amendments or any discussion on House Bill 2401? I will ask, Jason, I guess I would like for you to give us a update on 2401 so people can bring that to their memory.
Thank you, Madam Chair. So 2401 is the bill that provides prior convictions of a crime determined unconstitutional by appellate court should not be used for criminal history scoring purposes unless the basis of the determination of unconstitutionality is later overruled or reversed. You heard this one on the 12th, and this was the appellate issue dealing with the very nuanced criminal history scoring system and whether an offense counts or not if it's been declared unconstitutional at one point and later not unconstitutional, and how that would be used in your criminal history.
Thank you. Representative Vaughn.
Thank you, Madam Chair. I'm just getting my notes out here. I guess I'm not, my general feeling about 2401 is that it just feels like it's a knee-jerk reaction that is potentially too soon, dependent upon what the Supreme Court does in the State v. Phipps case. I feel like the outcome of that case could potentially resolve the issue surrounding reckless criminal threat. And instead of waiting to see what the Kansas Supreme Court does, I think this bill just adds further confusion to this issue. And I kind of brought this up in the questions that I was asking in the hearing, but I think my concern is that if we pass this bill and then reckless criminal threat is again considered as a part of the criminal history scoring process, and then the Kansas Supreme Court rules in State v. Phipps that, and I'm going to get these cases mixed up, that the Bottinger case is substantially different than the Counterman case. in which case, and I'm about to confuse myself, the reckless criminal threat finding by the Kansas Supreme Court would not apply to the state of Kansas, then I think then we would be going back yet again. So I just think it has the potential to generate this confusion where is it counted, is it not counted, is the Supreme Court ruling it, Kansas Supreme Court ruling, changing how that is handled by the courts or not. So it feels, like this is just a little soon in order to pass this law, considering that the Smith decision was just 3 weeks ago. So I'm not fundamentally opposed to it. I just think that this is a knee-jerk reaction. It's too soon. And I think it could have a lot of unintended consequences and throw confusion into the judges who are making these sentencing decisions. So I'm opposed to House Bill 2401. Thank you.
Representative Bohai and then Osman.
Thank you very much, Madam Chair. I'm trying to remember back to that hearing, and if I remember correctly, then the district attorneys et al. Are now using different charging, for lack of a better term, and so they're not continuing to use this. So while yes, we may have to change it again in the future, at the same time, we have, I believe the number was over 5,000 people that this could impact. And until that case is solved, I think we need to make sure that we continue to maintain the public safety of Kansans. So I'm in favor of putting this in the criminal bill that we're creating.
Representative Osman.
Thank you very much, Madam Chair. I agree with Representative on her comments. This is too early to make a determination as to what we're doing here. The decision was made approximately 3 weeks ago, maybe now 4 weeks ago. If this goes into law, if we pass this, bundle it, put it into law, by the time we put it into law, the other case that we're discussing may have already been settled. I don't know because we don't know the court's timeline, but it's likely that if this is a knee-jerk reaction in an attempt to fix it, it's not going to end up fixing it because the court will have already decided on the thing that we're trying to fix before this goes into law. That complicates matters significantly. I asked the question in our hearing, what is the rush? What is the harm in keeping this for a year in committee, seeing what happens, seeing what the ramifications are, and working it next year when we have more full information? I don't think I got a complete answer to that, but I don't think that there's a harm in tabling this bill. And so, no, I'm not in favor of working this bill and moving it into another bill. And I think that it frankly complicates the matter. If I were to expand my discussion to the entire bill as a whole, I would say that unlike Representative Carmichael, I have concerns, but I'm fine with the two bills as it is. Adding in 2401 is needless and makes this whole equation very much more complex, and I don't know if I'd be able to support the bill.
Representative Carmichael.
Thank you, Madam Chair. Where this problem really arose was in 2019. It's the case of Bottiger, State v. Bottiger, or Botger, which is discussed in Mark Bennett's testimony and others. And in that particular case, the court ruled that the criminal threat statute was unconstitutional as it related to reckless criminal threats. And looking at Mr. Bennett's testimony, he describes that if a threat of violence was made In reckless disregard for causing fear, it was unconstitutionally overbroad because it punishes conduct that may be constitutionally protected under some circumstances. And then it cites back to Watts versus United States, Virginia versus Black, and Elonis versus the United States, a well-established body of law. The prosecutors should have come to us shortly after 2019 and said, let's strike the unconstitutional clause that we have in our criminal threat statute. But of course, they didn't do that. That would be seen as weak on crime. So even though that concept would appear to be a pretty dead letter in the law, we've kept it in there. And so now the prosecutors have a problem that in many ways is one of their own creation. They wanted to preserve that old constitutionally impermissible concept in our statute in case someday the law changed some way. And now we find ourselves in circumstances where when we go back to count whether something is a prior or not a prior and whether conviction can or cannot be considered, we have to dig in and figure out what the circumstances were and whether defendant was convicted on the basis of the base statute or whether it was based upon the unconstitutional provision of reckless disregard for causing fear. And I'm honestly just not in the mood to bail them out over this. Let's wait and let the Phipps court decide this. If the Phipps court does something we don't like, then we fix it. But we don't react to every piece of what arguably may be dicta in a case and say this might have a consequence in some other case, and so therefore the legislature needs to act 3 weeks later. Caution in the adoption of statutes. Not having knee-jerk reactions to every decision of a court that we don't like, or one particular case where there may have been a miscarriage of justice, or even a case where in a perfect world somebody would have got extra time in the penitentiary. I want to tell you that conceptually, I don't think that's what our committee ought to be about. We ought to be concerned about big issues, real issues, determined doctrines of law, and to the extent we as a legislature have the ability to change those outcomes, that's fine. But we can get ourselves into a situation where we legislate on every newspaper article that one of us sees in our district. And I understand why legislators bring things that bring statutes because something bad happened in their town. But we have a much broader responsibility. So I agree with my colleagues that we don't need to be adding this bill to what I think is actually a good bill in Senate Bill 186. So I'm a no on this amendment, I guess, is the bottom line. Thank you.
Representative Barrett.
Thank you, Madam Chair. And I can definitely appreciate, all the comments that have been made. One thing to point out is I know this case is what brought it up, which is why we're talking about it. Obviously, the proponents spoke about this case, but it's also important for future cases that, we just provide clarity to the justices and those who are using these court decisions, knowing that, hey, the final court that heard this, the highest court that took this up, we're relying on what their opinion of the case was. Not any lower courts, but the last court that decided it. And so that's why I'm in favor of it. Thank you.
Do we have any other comments or questions on House Bill 2401? Representative Williams.
Thank you, Madam Chair. I move that we put the contents of House Bill 2401 into Senate Bill 186.
We have a second. Representative Barrett seconds. Okay, any other discussion before we vote on that? Okay, committee, you have heard the motion to put the contents of House Bill 2401 into Senate Bill 186. All those in favor say aye. Opposed, no. The ayes, I believe, have it. The ayes do have it. We will put the contents of Senate Bill 2401 and House Bill 2309 into Senate Bill 186, and we'll now vote on.
Before you do that, could I have my negative vote recorded on the amendment Placing 2401 into 186,
Yes,
please. Thank you.
absolutely. Anyone else? Okay, we'll now vote on and have discussion on Senate Bill 186 as it stands right now. Does anyone have any comments on that or questions? Representative Williams.
Thank you, Madam Chair. I move that we pass out Senate Bill 186 as amended favorably for passage.
We have a second. Second by Representative Bohai. Any other discussion on this bundle of crimes, punishment, and criminal procedure? Representative Osman.
Thank you very much, Madam Chair. I would say I like 186. I'm okay with 2389. And had it stopped there, I would have been a yes. I'm uncertain and I'm going to have to think on it, but I think that I may no on the entire bundle given 2401 added in, which I think is unnecessary. Now, do I think it's going to sway the entire House? No, because these are three very complex bills, and being able to accurately describe it even up at the well is going to be complex at best. But I think the 2401 is premature. I think we are putting our finger on the scales of justice rather than let the system play out and respond accordingly. And that's the way it should be. So thank you very much. I think I'm a no on this.
Do we have any other comments or questions, discussion on Senate Bill 186? Representative, would you like to close?
I close and move my motion.
Committee, you've heard the motion to pass Senate Bill 186 favorably for passage as amended. All those in favor say aye. Opposed, no. The ayes, I believe the ayes have it. The ayes do have it. We will pass Senate Bill 186 favorably for passage.
Madam
Yes,
Chair, would you
Representative
record my
Carmichael would
no?
like his no vote recorded.
Thank you.
Committee, we have a little bit more work to do. And so we're gonna look at the two bills that we heard yesterday. We're gonna start with Senate Bill 237. And Jason, if you could give us a brief reminder on Senate Bill 237.
Thank you, Madam Chair. So Senate Bill 237, you just heard yesterday, is the bill requiring the court to consider the value of individual retirement plan accounts when determining child support if a person loses income for certain reasons related to underemployment or loss of a professional license for misconduct, for example. It also mandates the use of those accounts to pay child support arrearages in certain circumstances, and it eliminates the exemption of retirement accounts and similar instruments from claims to fulfill child support obligations.
Okay, committee, what questions, comments, any amendments or anything on Senate Bill 237? Okay, seeing none, Representative Williams.
Thank you, Madam Chair. I move that we pass out Senate Bill 237 favorably for passage.
Do we have a second? Second by Representative Goddard. Any other discussion on Senate Bill 237? Okay, seeing none. Committee, you have heard the motion, or would you like to close?
I close and move my motion.
You've heard the motion to pass Senate Bill 237 favorably for passage. All those in favor say aye. Opposed, no. We have passed Senate Bill 237 favorably for passage. The last,
Could I have my
yes,
affirmative vote recorded?
today
for
I am
SB
just not on top of
237?
it. Forgive me. Yes.
Thank you.
You were affirmative, correct?
Yes, I
Okay,
voted in
great.
favor. It was not amended. I don't believe I voted in favor of it.
Okay. Okay, committee, now we're going to look at House Bill 2404. it down. Just trying to think. Okay, I don't even have that one in here. Okay, committee, sorry for that little sidebar discussion. So this is a bill, Jason, if you could give us a reminder of House Bill 2404.
Thank you, Madam Chair. So this is the bill that just has a new section that would be added to the Offender Registration Act that makes it unlawful for certain offenders to be on school property or attend school activities. Those offenders would be sex offenders who are 18 years of age or older and whose underlying crime that they're required to register for was a crime against a victim who was less than 18 years of age.
Okay, thank you for that. Committee, what I want to kind of say from the beginning, the way there was an identical Senate bill passed out of committee, and I don't know that it's gone above the line. Our reviser, Natalie, it's in a House shell. So when they passed it out of their Senate committee, they put it in a House shell. So it's passed per se either one of the chambers. And so I think it's very important that the House has a position on this. The Senate has given us their position, and now I think it's important that the House has a position. And so we're going to talk about that right now, and I'm going to call on Representative Osmond.
Thank you very much, Madam Chair. I know that there are a number of amendments, but let me first bring forth one amendment. This is the felony amendment, lowering felony.
Okay, while they're passing that, would you like to explain your amendment?
Yes, thank you very much, Madam Chair. Okay, so in the bill itself, thank you, it says, I don't know where specifically, but okay, yeah, line 14, it says, upon first conviction, violation of the section shall be a severity level 6 person felony. I'm changing that to 8. Now, if you look at your handy dandy sentencing range grid for non-drug offenses, a level 6 one-person felony is presumptive imprisonment, 32 to 36 months, as in 3 years in prison for what is effectively trespassing. That's what we're talking about here. And I realize that it's way more complex than that, but that is what it is. It's trespassing. And we're equating it effectively to use of explosions, aggravated arson. So I'm moving it down. You know, we looked at Missouri. In fact, that's a Class A misdemeanor. So I'm moving it down to Class 8 felony, one-person felony that is presumptive probation, 15 to 17 months. And the other two, I'm keeping the same. So upon a second conviction, severity level 5. Upon a third conviction, severity level 3. You can look at your chart and see what those are. But I think for the first offense, especially for ones that might be on the sex offender list that haven't had prison time originally, I don't think 3 years in prison on the first conviction sounds like the right solution.
What questions do you have for the bringer of the amendment or comments? Representative Barrett.
Thank you, Madam Chair, and thanks for bringing this. I will say that the 6, 5, and 3, I believe that comes from the Kansas Offender Registration Act. So when anyone violates anything within the Kansas Offender Registration Act, that's the way it's set up. So I believe that's where those felonies came from. It's just keeping it in line with what we currently charge people with.
Any other questions? Would you like to move your amendment? And I'll take a second.
Thank you very much. Yes, I would close and move my amendment.
Do we have a second? Representative Curtis seconds. Do we have any other discussion? Representative Barth.
Thank you, Madam Chair. I just wanted to get clarification from Representative Barrett about your comments. Is this something you think is an appropriate level of being at 6 or at 8 for this type of crime? Thank you.
I definitely see the representative's point. Missouri does have it as a misdemeanor. Other states have it as felonies. I personally would prefer to keep it with the Kansas Offender Registration Act, but I do see his perspective. I'll vote against it, but I'm not saying it's bad. I'm just saying why I'm voting against it.
I'll also comment. I think it's a good move. I think it's important to note that we did keep the second and third offense at those levels that are much more severe. But for the first time, it's still a felony. And, we're not taking it off of the felony grid. And to me, that seems commensurate with what the crime is. So, I guess it's a crime now. Okay, so I appreciate it in that regard. So any other discussion on the amendment? Representative Williams.
I just have a question for the reviser, and this is me not having my stuff in front of me. So I apologize, but is this the statute that it's amending, the Sex Offenders Registration Act? Does this language go into that statute? Or what statute is this amending?
So, Madam Chair, this, the amendment here is just in new section 1, but new section 1 will later become part of the Offender Registration Act. But right now, it's a standalone section.
Okay, great. Thank you, Madam Chair.
And Jason, to be clear, it's not amending the other penalties in the Kansas Registration Act, the Kansas Offender Registration Act, only this section for this particular offense.
Correct. So, Madam Chair, the current penalties for violation of KORA are in 22-4903, which is not amended in the bill. And these penalties, while they are similar to the ones in 22-4903, that's correct. They're not. They're replicated separately here in this section, so they do stand alone.
Okay, any other questions for the bringer of the amendment? Okay, would you like to, you kind of closed, but.
Thank you.
Go ahead.
You actually, the reviser actually scared me with KORA, as in a violation of KORA is now a penalty with 6 years in prison. Thank you. I believe, yes, I do close and move my amendment.
Okay, committee, you have heard the amendment to, the motion to amend House Bill 2404. All those in favor say aye. Opposed, no. The ayes have it, and House Bill 2404 has been amended. What other amendments, Representative Vaughn?
Thank you, Madam Chair. I have a couple of amendments just because I didn't know what the committee may be interested or not interested in. So the first amendment I was hoping to discuss is regarding the polling location issue that I brought up during the hearing. So while Jason's passing that out, I do have concerns if it is a trend where this is less common, but there are still situations in which schools are official polling locations for a county, and there could be people who are on the registry who are not convicted of felonies, and therefore would still have a constitutional right to vote at their polling location on Election Day. So this is just providing a very narrow carve out for that provision. And it says voting on provisions of subsection shall not apply to a person who enters onto school property for the sole purpose of voting in an election when such school property is being used as a polling place and the person leaves such property immediately after voting. And then it was also brought to my attention that occasionally religious services are also offered on school property. And so I thought that would be an appropriate thing to include in this amendment as well. So the second part of that exception is for a person who is attending a religious service when such school property is being used for religious service and the person leaves such property immediately after that service. So The idea is to create very narrow carve-outs for what I think are people's constitutional rights to vote and to attend a worship service if they so just happen to be taking place on a school property. So I would stand for questions.
Okay, what questions do you have, committee or Representative Vaughn? Would you like to move your amendment?
Yes, I would move my amendment.
Second by Representative Bohai. Any other discussion or comments or questions on this one? Okay, seeing none, would you like to close?
I close.
Okay, so you've heard the amendment to amend House Bill 2404. All those in favor say aye. Opposed, no. The bill has been amended, 2404. Okay, now committee, Representative Vaughn, you have something else?
Yes, and so this might be more of a discussion. I also have concerns about preventing enrolled students from being able to finish their degrees. So this amendment addresses that concern. So for this amendment, these concerns were brought up in testimony where, you know, I in particular think about the Romeo and Juliet situation that we have talked about previously on this committee, but in which there might be an offender who is 18 years of age, who is, or someone who's on the offender registration who is 18 years of age, but also has a right to finish their K through 12 education. This would allow them to enter onto the school property only for instruction and attendance. So we had contemplated, should we also include extracurriculars, but that was not included in this amendment. So this would only apply to instruction and attendance when the student is enrolled at the school in a unified school district that is using such property or an accredited non-public school that is using such property. And then to address potential concerns, I wanted to include a provision that would indicate that such school district may take actions as necessary to protect the safety of students and school employees. So I tried to make this more of a compromise language, but I do think it's important that if students are enrolled, that they have the opportunity to finish their K through 12 education. This would also apply to the situation that was brought up by the neutral testimony from KSAB for students who are enrolled in the IEP programs between the ages of 18 and 21. They would be allowed to finish their programs as well, which I believe is a federal requirement. So for those students, it would allow them to finish their education.
Okay, committee, what questions do you have? Representative Barth.
Thank you, Madam Chair. I do have a question for you about this amendment. I know you mentioned that it's supposed to be for like the Romeo and Juliet situation. I'm not sure I see that in there specifically where it says that. So I do agree that that would be good, but I don't see that it specifically says that.
Representative Vaughn.
Madam Chair, thank you. So I appreciate you clarifying that. So this doesn't, that is one of the situations in which that came to mind to me when I was contemplating. There could be situations in which there are students who, you know, should still be eligible to finish their degrees. And I think just more broadly, that should apply. So that is not specifically what this amendment does, to your point. It's kind of just part of my logic in bringing the amendment. So this would apply to all enrolled students. And there may be an amendment later that specifically addresses Romeo and Juliet, but.
Okay, I do have a follow-up question for you too, if you don't
Go ahead.
mind. I know it says that such school district or school may take action as necessary. I think what I heard from the folks and the proponents of it was that as it stood, that it did not make them have any extra work, that as the bill existed, and that I do fear that this would add additional work on behalf of the schools, especially those of high concern. Obviously, Blue Valley School District is a district who has a lot of buildings, a lot of schools, and that I do think that that could potentially put the onus on them, because I think they would be concerned with it, because I think they are really high proponents of this. So I don't know if you've considered that or have any thoughts on it, but that is a concern of mine. Thanks.
Yeah, Representative Vaughn.
Yeah, Madam Chair, thank you, Representative. That thought also occurred to me, so I wanted to make sure it was a may instead of a shall. So if, you know, they felt that certain additional precautions were necessary, they could take those precautions. I would say that I think if, you know, there were concerns, then I think in most situations, if it's a student of this age, and it was, and someone can correct me if I'm wrong, if it's a serious crime, I would imagine that they would either not be in the school because they're in juvie, or they wouldn't have completed their requirements in order to be back in school. So I think that takes care of some of those situations, but in case there was a situation in which they wanted to add additional safety protocol, this would enable them to do so.
Representative Barth.
Thank you. I appreciate that. I think in general, like your ideas of how you've teed it up with some of the Romeo Juliet, I like that piece of it. If you have an amendment, I think I could support that amendment. I don't know if I can support this one specifically as written though. And I wonder too about like just offering online schooling where if they were a true sex offender, where, you know, putting them with other kids might be of an issue, could be addressed further, then that's something I think I could support too. But as it's written right now, I don't know that I can support that. Thanks.
Representative Boheim.
Thank you, Madam Chair. Would this amendment restrict schools from using an online option if that was available?
No, sorry, Madam Chair,
Go ahead. Yep.
it would not restrict that.
Thank you.
Representative Carmichael.
Thank you. And by the way, I appreciate the representative's work on this and Mr. Thompson's work. Both of them worked hard last night to try to get us to a little bit better place on this bill. I would observe that this bill makes it unlawful for a sex offender who is 18 years of age or older, who's committed, who's had to register, to show up at school. I don't know about the rest of you, but when I graduated from high school, there were some of us who didn't get through quite as quickly as others. So we were 18 by the time we started our senior year. And there were others of us whose age changed during the year. The way this bill works at present is someone who was on the list because before they were 18, they had committed one of the applicable crimes, is still going to school because they're under 18. They're with their class in high school, and on their 18th birthday, they get kicked out of school. Now, maybe they complete their junior year and they say, no, you can't graduate. You can't come back to school. I understand the concern about the public safety. I really do. And I don't like I don't like the gestalt of registered sex offenders sitting in classrooms. But as I understand it, registered sex offenders who are juveniles sit in classrooms every day. And I don't think it's a good idea to take a kid who's in their last year of high school and kick them out. Because when you do, arguably, you're going to reinforce their bad behaviors and you're going to make the situation worse. So I think this is probably a good idea. Thank you.
Representative Barrett.
I'll have to agree with Representative Barth. I definitely agree with the intent of the bill, especially like with the Romeo Juliet. And some of our statutes do have some of those cutouts already. But it is the gray area where maybe the person doesn't get sentenced to a lot of time and is a more serious offense. And I understand, well, they should graduate, but they should just do that online. We have to remember they're the ones that committed the sex offense. They're the ones that did it. It's their responsibility. And so I do appreciate the intent. I'd probably have to agree with Representative Barth on why I couldn't vote for it.
Committee, do you have any other questions or comments? Representative Berquist.
I know I'm an outsider, but the representative always provokes me to more thought. So he or she is in graduation year. He's in his 18th year. He's in changed either before he got into his senior year. But what if he doesn't pass the test and he has to stay for another year? Does that give him another year? I'm just saying that you can keep it extended until he actually accomplishes graduation from high school, because that's the concern. So and that's why it kind of, to me, it leads down a rabbit trail. So.
Okay, any other comments or questions? Did you move your amendment yet? Okay, she moved and we don't have a second. Do we have a second for the amendment to House Bill 24? Representative Curtis, seconds. Go ahead, would you like to close and say something? Yeah.
Yeah, I would just say, I think, I appreciate the discussion. I think that one of the safety considerations the school could make is to invite that student to finish their education online. I think that would be appropriate in the circumstance, and that wouldn't add an additional burden to the school district if they have an established online program. So I just think that this allows students to finish their educations while also creating the ability for the schools to take certain safety precautions in mind, and creates a very narrow ability to do that. It's only for instruction and attendance. It limits their ability to participate in extracurriculars in that sense as well. So my intent was to make it very narrow, but just to address some of the concerns that were raised in testimony. So with that, I would move my amendment.
Okay, committee, you've heard the motion to amend House Bill 2404. All those in favor say aye. Opposed, no. I would say the ayes have it, but it sounded like to me the ayes have it. So the bill will be amended with the Vaughn second amendment. Okay, committee, any other amendments? I think I have one. This might be a good time to do that one. Yes. Okay, this is simple. Committee, vote however you would like to on this, but I'll just tell you my reason for bringing this. It's simple on page line 11 of the bill. I'm just changing the age of the victim to less than 16 years of age, because 16 is the age of consent. And so it didn't make sense to me to have the victim be 16 or older, because they can consent. So this, I feel like at under 16, it's a more serious crime. It's definitely, if it's 16 or older, it might include that Romeo and Juliet situation. The victim could be 16. So 16 being the age of consent, I thought younger than 16 is better to put for the age of the victim. That made sense to me, because it's my belief that there's a difference between different kinds of crimes against sex crimes. Some of it's Romeo and Juliet, some of it is abhorrent, horrible things with children. And I kind of just wanted to differentiate between those two things. So with that, I'll move my amendment. Do I have a second? Representative Bohai seconds. Discussion on that one. Representative Goddard.
Thank you, Madam Chair. Does this amendment create a situation where if the victim was over the age of 16, are we still banning this individual who's 18 or older from the school property?
No, or yes. No. I said no, and Jason was doing this. Yes. Yes, that would be true. So the sex offender is 18 or older. The offender, if the victim is 17, 16 or older, then they would not be included in this, because 16 is the age of consent.
Right.
That was my feeling about it. But again, committee, it's up to you all. Did you have a follow-up to that, Representative?
Well, the way I read this, if the victim was less than 16 years old, the way that it's written here,
Then
with the amendment,
then the offender would be banned from school if the victim was less than 16.
Okay, then my question was, what if the victim was 17? Are they still banned from the school?
No, they're not.
No, I guess I'm a little confused. Is that provided for in another piece of legislation, or does this one do it?
I mean, the way the bill reads, so the offender is 18 years of age or older when the crime was committed. If the victim was 16 or 17 or older, then that sex offender is not banned from going on school property. In my opinion, when you're 16 and you can consent to something, then it's more often a Romeo and Juliet situation. If the offender is greater than is 18 and the victim is 16, so we have a case here that there could be an offender who's 18 and a victim who's 17. And then that 18-year-old would be banned because they would, if there was a crime committed, they would be on the offender registration. I felt like 16 made sense to me because our testimony was about child abuse, child offenders. They're the ones that recidivate. You know, it just was so much about children that I had trouble thinking that 16 being the age of consent, that made sense to me. Again, committee, I'm leaving it up to your will.
Thank you, Madam Chair, for your explanation. I'll just have to think about it for a
Okay.
while so I can get it
No
straight in my mind. Thank you.
Representative Carmichael.
I also think it's fair to say that we're talking about, was the victim under 16 at the time of the offense?
Yes.
So if the offense happened 2 years ago and a 15-year-old is now 17-year-old, the assailant doesn't get a get out of school free card. It's based upon the age of the victim at the time. And I think what the chair's amendment says is we're going to make that cutoff at the quote unquote age of consent, even though it's not necessarily consent for every crime in the statute book.
Representative Barth.
Thanks, Madam Chair. I don't know if my questions, if it's been answered yet or not. I feel like it's that time of day where my brain is a little slower right now. So I just want to confirm that with the 16 years of age, that if they're older than that and it was like a sex crime or waste, is that, like, where does that fall in the, how does it affect that population? I mean, I don't think that's what the full intent of the bill is, but I just wanted to clarify my mind for that. Thank you.
So right now there's a age of 18 years of age. So we know there's sex crimes committed by 30-year-olds on 25-year-olds or 20-year-olds. So the bill at the moment has that the victim was 18, or excuse me, less than 18. And my concern is for younger victims. I feel like that's where the more heinous crimes happen. And so I thought it made sense to change it from 18 to 16. So that was my thought. Representative Esau.
Thank you, Madam Chair. I think I understand where she's coming from, because as I saw this situation presented to us, the concern was those who are preying on children. And I'm trying not to be too graphic here, but the photos that they might take or other actions or thoughts that they might have were directed towards young children. That it wasn't, not that the other crimes aren't bad, I don't mean that, but this was directed towards children. So I can understand where you're coming from with this amendment, even though it sounds complicated. I don't think it is as complicated as it sounds.
Representative Barrett.
Thank you, Madam Chair. I can see the point. I know other states that have done this have created that 16. I guess one question would be, though, is it's not restricting what the offense was. So if the offender, raped a 16-year-old, then once they get out of prison, once they're out, then they could still go on school property though, right? And I can see both sides. I'm just trying to show that the other side too is that it could be a pretty serious offense, and they're now allowed on school property.
Absolutely. They're still on the offender registration list as they always have, as they have been. This bill is specifically, I think, was addressing what happened in Blue Valley as we saw. And so I totally agree with what you're saying. I think my thought was this bill in particular seemed like it was targeting children. And it was, I think it was an elementary school even that the incident happened. And so that's what my thought was. It's kind of like what Representative Esau says, that it's what does this bill say? Not that that person should not be on the offender registration list. It's just particularly for this bill. So, yep. Did I see your hand? I feel like I keep seeing your hand up and down. Okay. Representative Goddard.
Thank you, Madam Chair. I'll take another bite of the apple here. In the very first part of the bill, it says what the act is. It seemed to me when I read that any adult sex offender would be restricted from entering school property or attending school activities.
The way the bill is written, only if the victim was under 18.
So that seems to be inconsistent with the title of the bill or the description of the bill.
Jason, would you like to comment on that? Thank you.
Madam Chair, I don't know if you have one yet. Nope, you don't. But in preparing some of these amendments, and I was very careful in my explanation to say that is the offenders with certain qualifications. The word certain probably should have been in there. It is certain adult sex offenders. It's not all adult sex offenders, and sometimes the title doesn't quite capture everything that it should. But I will say, in defense of the title, it is constitutionally sufficient in that it describes the content of the bill, but it is not quite as accurate as I would like our title to be. So that would be something I will fix. You know, while merging all of these amendments into one final package, if the committee adopts it, that's one thing I would clarify.
So you're saying you would say making it unlawful for certain adult sex offenders to enter. Mm-hmm.
Yes.
Thank you for pointing that out.
To me, that would be consistent with the verbiage that's in the bill itself.
Yes.
Thank you, Madam Chair.
Very astute of you to point that out. Okay, committee, any other discussion on this one? Okay, did I get a second? Okay, thank you. Okay, committee, you've heard the amendment on House Bill 2404 to and I close. All those in favor say aye. Opposed, no. Okay, we have one more amendment. The ayes have it. Okay, so who else would like to offer an amendment? Representative Martinez. We'll wait for you to explain it until
Fine.
it starts to get passed out, if that's okay with you. Okay, Representative Martinez, would you like to explain your amendment?
Yes. And if this is my first time doing this, so
Oh, you're doing
feel free to
fine.
correct.
You're doing fine.
Well, my amendment comes, do I explain why or the amendment itself?
Both? Yeah.
Okay.
Yeah.
Okay. Well, let me explain why first. As I stated yesterday during the hearing, it was a concern of mine that the children of offenders on the registry would not be able to have their parents in the conferences and going to their sporting events and music programs, anything that has to do with school where they're going to, kind of want a parent there. To me, parental involvement it's essential for social and emotional development, for mental health. It's important that a parent be involved at every aspect in their growing years. It could make a difference in the way that they develop, the way they see things in life, the way that they become parents. So that's important. So that's kind of why I was thinking about this particular amendment. The provisions of this subsection shall not apply if such offender is a parent or guardian of an enrolled student and complies with any procedures established by the local school board to monitor the whereabouts of the offender for the duration of such offender's presence on the school property or attendance at the school activity. A local school board may create such procedures and, if created, shall publish such procedures on the board's public website and include a method to notify parents. If any plan approved for such an offender to be present on school property or attend a school activity at least 14 days prior to such presence or attendance. And I want to also say that the offender registry, they were required to register for life. So some of these offenders have changed. And they went on to have families and children who attend school. So I would like to see those particular parents be able to take part in their child's life. Like I said, it is essential and vital that a parent be able to maintain that bond with, at home, in community, and at school with their children. And it's so important that the children be able to look up at a basketball game and see their parent there. I mean, if a school board can create these policies and procedures and know what the whereabouts of this person, this parent, and like I said, they can write a letter and get approval, whatever the school board would create to create safe space. Because I agree that we need safe space. We need for our schools to be safe. And I agree with the premise of the bill, but I don't agree with the fact that these children of these offenders, and it may have been before these kids were born, they should have to do without their parent at an important time in their life. So that's my amendment. Thank you.
You did a good job. Okay, committee, let's ask some questions or have discussion about this amendment. Representative Barrett.
Thank you, Madam Chair. I guess, again, I do appreciate, the intent behind the bill. I would just caution in some of the cases we've seen here locally where, pedophiles intentionally find either single moms or they have kids as their biological child and they offend against that child. And so that's what really scares me about that is someone can come off as a really nice person, but you have no idea what's going on behind the doors of their home. And so for that reason, I can't support it just because someone could play off as I'm this great person and there's some terrible stuff going on.
Other Representative Barth.
Thank you, Madam Chair. And Representative Martinez, I actually absolutely feel for what you're talking about with the parents and such. I mean, these kids are in just a horrible, unfortunate situation. But at the same time, the parent is paying for the consequence, and it's unfortunate that children have to be a part of that. But we are talking about sex offenders who do have recidivism issues. And I have a little concern about a couple of the things with the monitoring of the whereabouts. Again, it goes back to the school districts did not want to have additional responsibility. And I think that's kind of like what I would call babysitter standards, where they have to monitor and watch them. And I think that would put a lot of the onus back on the school districts and the school boards, which I think would be a liability that they would not want to be responsible for. And then the other thing I think is too, is I actually think this probably cancels out the entire purpose of the bill, which is allowing the sex offender now to go onto the school property. So those are my concerns with that. So I would definitely be a no on this one.
Representative Carmichael.
Thank you, Madam Chair. A couple of observations here. First, this amendment doesn't apply to boyfriends, girlfriends, step parents. At least I wouldn't read it. Is a parent or guardian, somebody who's married to baby mama or daddy or whatever isn't a parent. And I mean, we could dig into that a little bit deeper, but just by virtue of marrying a child's parent does not make you the parent of the child. You have to go through adoption procedures, et cetera, to get to that stage. But think about the way kids are. Kids are cruel, not because they're bad, but they're cruel to other kids. And so little Johnny, I'll pick little Johnny, I know little Johnny pretty well. Little Johnny gets teased all the time. Your daddy never comes to your ball games. Your daddy never shows up for you. Your daddy doesn't love you. Or your daddy must be a pervert. Now that's what's going to happen when this happens. It's bad enough that particularly fathers aren't involved in the raising of their kids and their families, but to subject a child to teasing when instead you can limit the parent's access to the school. You can limit it in ways that the school district believes are appropriate for their school. My guess is, and I heard about the story at Blue Valley, I don't mean to diminish it, but my guess is that if the school board puts a sign up on the front of the school that says child molesters welcome here, don't worry about it, we're not going to do anything, come on in, that the electorate would correctly throw the bums out. But to tell children that you're going to be ostracized, you're going to be described as the son of a pervert, and you're going to be teased throughout your educational career, particularly in younger grades, I would argue makes the familial pattern of child abuse all the more likely, because if a kid is ostracized and accused of being a pervert because his dad was a pervert or his mom was a pervert, you just perpetuate a cycle of child abuse. And I think it's much better to have closely supervised parental involvement in the schools with kids, even for folks who may have, yes, a conviction that they've done their time, paid their debt to society, or even worse, people like a friend of mine who was convicted 25 or 30 years ago and found himself on the list, can't seem to get off the list. He's raised a beautiful, wonderful daughter with his new wife. He has a respectable job, and nobody told her that your daddy can't participate. So I think this is as good a compromise as we can make given an unfortunate circumstance, and I support the amendment. And I urge you to listen to someone with a social work background, because their opinions are just as valuable as those who've been in law enforcement or the law. Thank you.
Representative Boheim.
Thank you, Madam Chair. Two questions. First, reading the second balloon saying the provisions of this subsection shall not apply, would the carrier of the amendment be opposed to changing the word shall to may?
No, I would not be opposed.
Okay. Maybe there's something to think about. Okay, and then my next question is, it's my understanding that the school in question allowed someone on site because they were kind of classified as the parent. The live-in boyfriend was classified as the parent. I know that's not how the law necessarily describes it, but how do we then educate the schools of, okay, this is the parent, if it's a step parent and they have an adopted, like, I feel like that gets a little bit muddy. So could we talk through that a little bit?
Correct me if I'm wrong, if someone knows in Board of Education, works in the Committee for Education, but just dealing with kids who have to provide birth certificates and PIFs and things like that to us for athletic organization. When we require age verification, we get their information from the school that says it's either a copy of, well, they'll either provide a copy of their birth certificate or a PIF, a pupil information form. And that tells us who their parent is. So the school has access to those things. And we deal with kids from kindergarten to 8th grade.
Committee, any other questions? Would you like to move your amendment?
Thank you, and I move my amendment.
Do we have a second? Representative Curtis will second. Okay, would you like to close? Anything else you'd like to say?
No, thank you, I
Okay.
close.
Okay. Committee, you've heard the amendment to House Bill 2404. All those in favor say aye. Opposed, no? Okay, I think the chair is in doubt on that one. If you are in favor of the amendment, could you raise your right hand? All those opposed, raise your right hand. I have that the amendment passed 9-7. Okay, we have amended. Okay. Okay, Representative Vaughn.
Thank you, Madam Chair. I'll keep it quick, and I appreciate the committee's indulgence. My very last amendment is just also in regards to the neutral testimony that was brought by KASB, where there were concerns about potential conflicts with federal laws and regulations. So all this does is say that it does not apply when there is, I think, just a federal law. And the example they specifically used, and I also tried to make sure that it was tailored. The example that was used in testimony was an IEP meeting where a parent is federally allowed or was allowed under federal law to participate in meetings regarding their IEP. So this is just a narrow carve out regarding provisions of this subsection shall not apply to a person who enters a school property for the purpose of participating in a meeting as authorized by federal law or attending school as authorized by federal law. Oh, wait, hang on. I guess that might need a cleanup. The attending school is authorized by federal law. I think that was addressed in the other amendment. So the intention was only in the situations in which they're participating in a meeting as authorized by federal law. Yeah, period, strike everything after that.
Okay, could you repeat that just for everyone's understanding?
Yes. Sorry, everybody. We were so I would like to offer the amendment with the change that after it says as author, so the provisions of this subsection shall not apply to a person who enters onto school property for the purpose of participating in a meeting as authorized by federal law, period, strike everything else after that. Because we dealt with that earlier. And I think we all know that federal precedent exists. But I think what KSAB was asking for is just clear guidance on whether or not this law would apply in those circumstances in the hope for just avoiding potential lawsuits or other issues that may arise under federal regulations, specifically with IEP meetings and similar meetings that are required by federal law.
Okay, committee questions. Representative Bohai.
Thank you, Madam Chair. Bringer of the proposed amendment. It's my understanding that parents and people don't have to be present for the IEP meeting. They can join virtually. So I guess my question is this amendment necessary if we have the capability to join an IEP meeting virtually? And many of them do because they're at work.
Yeah, I think it's a valid question. I think that that I don't know exactly how the federal law is written. I didn't have time to do that research. So I did this in hopes of providing very specific, narrow, a very specific, narrow exception to an issue that was raised by a conferee. I don't think anything would prohibit them from attending virtually, and that could be a solution in this case. But in the case that there were other requirements in federal law, I just wanted to make sure that the bill was clear.
Representative Lewis.
Right, so I think I understand the purpose of the amendment. I'm wondering, though, if we're actually getting to the point. I don't know if it authorizes the right word. I think what you're getting at, if I'm not mistaken, is the idea that if any portion of this bill that amended bill we're going to pass out conflicts with federal law with respect to the right of a parent or guardian, or actually the person to attend, then it's null and void. That would be more appropriate than, I mean, when we're saying the federal law authorizes somebody to be there, doesn't necessarily mean that the federal law would preempt the state law that says they can't be.
Madam Chair, I would agree that language, I think, is better in the circumstance, and I'm open to that change.
So we might reject them suggesting maybe we vote down the amendment and work on a floor amendment.
Go ahead. I mean, say, and then I'll call Representative Vaughn and then Representative Carmichael.
I'm open to that suggestion pending further discussion or suggestions by the committee.
Representative Carmichael.
Thank you, Mr. Chair, Madam Chair. I'm sorry, Susan. I think we're pretty close to on the same page here, actually, okay? We just passed an amendment that says that the school district can implement procedures to allow these folks to come on campus as a parent, which may be sufficient to get them into the meetings in the first place. But I also think on a broader scale, maybe we do want a savings clause, and that's not the right word, but says, that I don't know the language, but I know we can find the language by the time it goes to the floor. And rather than defeating the amendment, maybe we just all ought to look at each other and smile and say, we're going to use good faith efforts to see if we can't draw a floor amendment that better accomplishes that purpose, so that a school district doesn't find itself in a position where it has to comply with the federal law and at the same time doing so would place it in violation of the state law. But for the time being, I can support this bill as is, given the amendment that was just put on a few moments ago by a close vote.
So Madam Chair.
Representative Lewis.
I'm not necessarily tracking. I think we're on the same page. Are you suggesting that we vote down or up this amendment?
I'm suggesting that the maker of the motion decide with all of us in good faith saying we're going to fix it, to withdraw the motion with the consent of the second, and we can all go to supper.
I would like that very much, especially the latter suggestion.
Or even have a cool beverage. I like lemonade.
Representative Vaughn.
Thank you, Madam Chair. I appreciate the discussion, and I would make that motion to withdraw this amendment and continue the conversation at a later time.
Representative Curtis was the second. Is that okay? Okay, very good. Thank you. Okay, any other amendments? Representative Osman.
Thank you, Madam Chair. Hold that cool beverage for just 1 second. This is a large but simple amendment. Large but simple amendment. Madam Chair, I and members of the committee, I am just electing to effectively add in the contents of HB 2173 into this bill. And that is a bill that we passed out of committee already as presented. There were 10 proponents, 1 neutral, no opponents to the bill. The bill just has never made it above the line. And it was a good bill. It was supported by this committee. And I'd like to give it another bite at the apple here. It is authorizing certain offenders to petition for relief from registration requirements under the Kansas Offender Registration Act. Sorry if I didn't explain that. It's HB 2173. It is the petition for relief for sex offenders.
Committee, what questions do you have for Representative Osman? Representative Carmichael.
Thank you, but it's not for all sex offenders, is it? It's just for those who got caught in that window where the law was changed, or is it for all sex?
No, it is that, exactly right. That is just for that specific window, given a specific judicial intervention. Should they ask for the petition? Should they achieve those requirements?
The people who at one time had an expiration on the requirement to register, and then we went back because it was civil and they got caught up in becoming a permanent registry rather than one who had a specific limitation. Are those the people that this impacts?
That is exactly correct, yes.
Thank you, Madam Chair.
Any other comments? Representative Martinez.
And is that at a judge's discretion on a case-by-case basis, like their particular
Yes.
case? It's, okay.
If the petition would be
Just
granted.
to
That is correct, yes.
clarify. Okay.
Representative Barrett. Sorry.
Thank you, Madam Chair. And the bill that was brought by Representative Schreiber, I know we were hoping to bring that back at some point. I had an amendment to hopefully make that bill more palatable so it could be brought above the line. I'm afraid, though, that if we attach the bill as it currently stands to this bill, it's going to nuke this bill, and they're not going to bring it above the line. I think there's so just, I'll leave it to everyone else, but that's the only reason I'm fine with Schreiber's bill, Representative Schreiber's bill, with the amendment I was hoping to bring to it, but I think attached to this, it won't be brought above the line.
Any other comments? So committee, if you remember, we passed House Bill 2173 out. It was below the line. It got blessed. It got sent to the Calendar and Printing Committee, and then it got sent back to our committee. And we've had discussion on what we're going to do with it. I'm going to leave it completely to the will of the committee, what you would like to do with this. As I mentioned, when we first started working this House Bill 2404, the Senate put their version into a House bill. So they have a position, and it's already per se passed one chamber because they put it into a House bill. So I don't think, regardless, this bill was going to be above the line, 2404, even with all of our amendments, but it gives us a House position with the amendments that we've put on previously. So I want that to be clear. As far as adding the other bill into it, I am completely leaving that up to the will of the committee, what you would like to do with House Bill 2173. That's just going to be up to you guys. So any other discussion on that? Representative Esau and then Schreiber.
So as I'm understanding it, one of our representatives may have an amendment to 2173 that you think might make it more likely to get above the line. Could that amendment be put into 2404 if we amended 2173 into 2404? I'm not trying to get you to say what your amendment is. I'm just wondering what the odds are of that.
Madam Chair,
The amendment's ready, isn't it? Okay, so the amendment is ready, but we don't have the copies with us right now, but what? Yep, well, I don't know. Yeah, we
I'll just
could.
clarify, I didn't know whether we'd want to do it in committee or if it would be a floor thing if that's what we were going to do.
Okay, hold that thought for just a second. Representative Schreiber.
Thank you, Madam Chair. So it's your thought that 2404 is not going to get on the floor anyway, right? But it gives us a position. So, oh, go ahead.
That's my thought. I think the folks that really wanted this bill to pass put it into a House bill on the Senate side because they wanted to expedite things. Our leadership could put it above the line. I've not spoken to them about it. I don't know if the other representative in the room knows if the leadership intended to bring it above the line. I have not spoken to them about it, but my belief from speaking to my counterpart on the Senate side was that it was in a House bill so that it could just go straight to conference. But I felt like it was important that we had a position. But I don't know, Representative Estes, if you have any helpful, information about if this might go above the line or not.
I have no idea. Thank you. Sorry.
Okay. That's okay. Yeah.
So if we added Representative Barrett's amendment to 2173 and added it in 2404, that would give us a position on that material in conference. Is in my understanding? Okay.
Committee position.
Exactly.
It's a committee position. Just to reframe, it's what we've done today is a committee position. Right. Yeah. Thank you. Good. Unless it goes above the line, then it would be a. Representative Osmond.
Thank you very much, Madam Chair. I want to ask a question of the revisor, if I could.
Okay. All right. Sorry, we're kind of talking about procedure. One thing I probably didn't mention was the Senate put it in a House bill. It still has to pass over the Senate floor. So that does have, then that language would have been passed by the Senate. It would be in a House bill. We would go to conference on that. And the subject would be the Kansas Offender Registration Act. And then we could put things into it because of the subject, but I wouldn't want to put anything in that we hadn't talked about, at least in committee. And better even if we had passed things across the floor, but the House floor. Representative Vaughn.
Thank you, Madam Chair. I also while I was thinking about this, we talked about this earlier. I think it's important to note too that if we amend in the language of 2173, it doesn't remove the contents from the actual 2173 bill. So that by itself could still come above the line with Representative Barrett's amendment. It would just also be in this bill, so that in the situation in which it did pass the House, this would be conferenceable language, or it did pass the Senate, then this would be conferenceable language as part of that conference committee. So I think, having thought through that I would be in support of this amendment.
Representative Schreiber.
But do we need Representative Barrett's amendment at this point? Or,
Would you like to offer your amendment?
or
Okay, he's happy to do that. He's happy to do that. I mean, his amendment, the language of his amendment doesn't have to be amended into House Bill 2183. It could just be language that was also added to House Bill 2404. Yeah, it's marked up on that one, but the language would be under, okay, Representative Vaughn.
Thank you, Madam Chair. I was just thinking if it's not amended into this bill and in the original 2173 never comes above the line and isn't amended into that bill, then it wouldn't have passed even a committee. So then it probably wouldn't be conferenceable unless it was also amended into this bill, if that makes sense.
So language that is of the same subject can go into a conference committee. Yeah, okay, Jason's going to read the rule to us.
All right, thank you, Madam Chair. I was looking up the conference committee rule because it's a little broader than we sometimes remember. Only subject matters which are or have been included in the bill or concurrent resolution in conference, or in bills or concurrent resolutions which have been passed or adopted in either one or both houses during the current biennium of the legislature, may be included in the report of the conference committee. So it's subject matters which have been included in something in conference or which have been passed or adopted in either one or both houses. And then how you interpret subject matters is an issue for you to take up on the floor.
Okay, Representative Barth and then Barrett. Did you have Representative Barth?
Okay, thank you, Madam Chair. Committee, I'm at the point where I'm a no on us even adding this into it, and we're making it way convoluted, and I just feel like we are going to we've done so much to this bill already, which really changed the original intent of it, and to add this complete new bill into it, I feel like it's just way messy now, and I think Representative Barrett should save his amendment if it's a good amendment for the bill to keep it clean, that if it does have the chance, it could never come above the line, it could come above the line, but I feel like you're going to waste potentially a good amendment on a bill that has a lot of support from, I think, from a lot of people here, and that's just my thought. So I just would like to move on to the next thing and voting on this if we could do that, but I'm ready. Thanks.
You calling the question?
Calling question, yes.
Okay, great. Let's go ahead and vote. Committee, or I did say
Point of order.
Okay.
We don't act like the Senate. We don't call questions. We have a motion to close debate and a vote.
Okay, I'm first going to call on Representative Barrett because I did say that I was going to call on him. So Representative Barrett.
Thank you, Madam Chair. I guess we'll see if this passes first, whether I offer an amendment or not. But I would tend to agree with Representative Barth that maybe we just keep it clean with the amendments we've already added. I shouldn't say clean, but as it's been currently amended. Thank you, Madam Chair.
Okay, is there any other discussion? Seeing none, we're going to go ahead and vote on the amendment. Would you like to close? What? I'm sorry. We did not get a second. I'm so sorry. Representative Schreiber seconds.
All right, thank you, Madam Chair. The hour is late. I understand. I really appreciate all the discussion on this. I'm just, I'm not the Speaker of the House. I'm not Majority Leader. If I was, I wouldn't be in this chair. So I don't know what's going to happen. I don't know what's going to happen on 2404. I don't know what's going to happen on 2173. I'm trying to look out for all eventualities and see what we can do to get a good bill above the line. That's why I brought this amendment. So with that, I close.
Okay, committee, you've heard the motion to amend House Bill 2104 by putting the contents of 2173 in it. All those in favor say aye. Aye. Opposed, no? I believe the ayes have it. So we have amended again House Bill 2404. Now, committee, are there any other amendments? Representative Barrett.
Madam Chair, I guess I could print this off really quick for everyone at my printer or email it. What would you prefer?
Okay. Yeah, I mean, since it's already made up, it's not a conceptual amendment. Can you send your amendment to Lene and she'll just print it up right here?
Okay.
You go get the copies? Okay, okay, is that easier? What do you want to do? Yes. Okay, okay, while we're waiting, Lene's going to pass out some draft minutes and we can vote on some minutes.
Madam Chair,
Yes.
may I make a comment?
Absolutely.
There is a particular member of this committee that tried to fine me today for using the word muck.
Yes.
And I'll tell you, Madam Vice Chair, we've sure mucked up this bill. All right.
Madam Chair.
Well, Representative, now that you started,
Right.
you started the fining people on the floor, so that was your group that started all of that. So, okay, committee, you were looking at minutes for March the 5th and also March the 6th. So if you would just please, I know it's hard to think back on that, but if you would just take a quick look at these and see if you have any changes to these minutes. Are you looking at the minutes, Representative Berquist? Oh wait, you weren't here.
Right there. That's right. I could go, yeah.
Okay, committee, are there any additions or corrections to the minutes for March 5th or March 6th? Do you need a minute? No conceptual amendments to the minutes. Thank you. Representative Vaughn.
Thank you, Madam Chair. I would just make a motion that we approve the minutes.
Do we have a second? Second, Representative Schreiber seconds. All those in favor of approving the minutes for March 5th and 6th, say aye. Opposed, no. Okay, our minutes are approved, and we may have to have a meeting at the rail at some point to finish off the amendments, or to finish off the amendments. Sorry, minutes. Oh my gosh. Okay, but I've always wondered, if you have a meeting at the rail to do the minutes, and then you have to have the next meeting to do the minutes of that meeting?
Looking in a mirror.
So
That-
it's the rail exception? The rail exception? Okay. Schreiber, no, did Schreiber second? Yes, Schreiber seconded the minutes. Okay, we're so close. I did, didn't I? Found it. Okay, we have the amendment. Representative Barrett, would you like to explain your, we don't have it yet, sorry, you're getting it passed out. Representative Barrett, would you like to explain your amendment?
Thank you, Madam Chair. Yes, so this amendment, I think, one side of this bill is to get those who were retroactively affected off. I think I'm adding a counterweight to it on the other end by, if you are a lifetime registered sex offender whose offense occurred to someone under the age of 18. Again, this has to be for a lifetime offense. The victim was under 18. You cannot live within 1,000 feet of a school. This is legislation that numerous states have, including to our east, to our south. I think, again, it's a good amendment that adds a counterweight. And like I said, these are lifetime registered offenses. I do have those pulled up now if anyone would like to know what those are. But these are not the 15-year, the 25-year. These are the serious lifetime offenders.
Okay, questions, Representative Bohai. Oh, why don't you go ahead and move your amendment?
I would like to move it with the technical amendment or the technical change that the reviser mentioned while he was passing this out to me. If you could further explain.
Okay, Jason.
So, Madam Chair, as I noted, this is marked up on HB 2173. Two provisions that are included in here are already included in 2404. That's the amendment to 224901, making the new section part of the act. The bill already does that, so I would just make both new sections part of the act, right? And then the definition section is included because I was adding a definition of school property, and 2404 already has a definition of school property that you're using. So really all you need is new section 1, which is attachment A. That's really what the amendment would be, plus all the other technical cleanup I have to do to merge everything together. So.
Okay, thank you. Would you like to move your amendment?
I would, and just to clarify, yeah, attachment A will be what the changes are. But yes, I would like to move that.
Representative Bohai seconds. Representative Osman.
Thank you, Madam Chair. I have a question for the carrier of the amendment. Is your intention, or is the motion to amend 2173? Is it to amend 2404? Or is your intention to do both?
Oh, 2404.
Yeah, what we're working right now is 2404. So 2173, that language was put into 2404. 2173 is still in our committee, down here on the
Yes.
list.
That.
So we're not working that bill right now.
I understand that. So that's my point. That is the question. So your intention right now is just to modify 2404 with the amended language of that was included in 2173. But if I can ask, is your intention also to amend, should this pass, to amend 2173, which is still in committee? Or is that?
If 2173 comes up, and I would plan on adding it, or whatever we can do to make the bill more palatable for everyone.
Okay. All right, thank you.
Representative Barth.
I think that everybody got confused with what you had said there, but I would just say, Madam Chair, that I actually think if we just had the prohibiting certain sex offenders from residing within 1,000 feet of any school property added as the amendment to that part of it. I think we heard yesterday that that was a needed part of it, that having them within a school district or within a school for school property was something that was favorable.
Did you ask a question at the end? I'm sorry. You said what?
I said that that was favorable.
Yes, okay, all right. Any other questions? Representative Carmichael and then Vaughn. Okay, Vaughn and then Carmichael.
Thank you, Madam Chair. I'm reading through this. I was just wondering what the grandfather provisions are.
That's a great question, and actually, I forgot to mention that. I wasn't planning on bringing it, so I didn't have everything out. So yeah, if you already live, if your residence is already within the 1,000 feet of a school, you are grandfathered in. You do have to notify law enforcement within, I believe the bill says within 7 days, or if you do move now, that does apply to you. But if you already live there, then you're grandfathered in. Secondly to that, if you have a house, and let's say a school moves in, and Bill's right next to you. Once again, that's already in this amendment that you're grandfathered in. Again, you need to notify law enforcement before 7 days after that school opens. I believe it's 7 days, and then again, if you move, that would take effect again.
Representative Carmichael.
Yes, my initial questions were going to be about, excuse me, grandfathering. And so I guess the first inquiry is, July 8th, people have to have registered if they live next door to a school, 7 days a week?
No, it's not registering. It's just notifying the law enforcement agency that you're already registering with that, hey, this school's been built. I'm going to be within that 1,000 foot, or I do live within 1,000 foot. It's putting it just so law enforcement is notified that this person is there.
And we give them 1 week after people have lived here for 30 or 40 years? You've got 1 week to send a letter to the police department to tell them you live where you've always lived?
And I'll verify it's 7 days, but a lot of this came from what other states are currently doing. And again, it doesn't say it has to be a letter. You just need to notify law enforcement just so they're aware. So a simple phone call.
I strongly recommend people not make a simple phone call because you won't have any documentation that you did it and you'll find yourself in the hooscow again. But has this idea, this concept, been the subject of any hearing anywhere in the Kansas legislature this session?
No.
Has there been any opportunity for people like at the Board of Engine and Defense Services or a whole host of other people who are concerned about these issues to come to the legislature and make their opinions known?
No, there has not.
And some other state somewhere has adopted this. Has there been an effort made to see if these laws from other states create conflicts with Kansas law, or did we just take something from another state and stick it in an amendment and now we find an opportunity to offer it?
Well, first on the first part, well, it did conflict with Kansas law. I can't think of any Kansas law it would conflict with. However, like I said, Oklahoma and Missouri both have this. Numerous states have this, in fact. So we're just adding to pretty similar language to what other states use.
Madam Chair, my opinion is we're moving way, way, way too quick with this honestly radical idea. I'm not going to say it's a bad idea, but to do something this important with no testimony, no hearing, no notice to the public, no opportunity for anybody to be heard, to do it in a committee where we were at the end of the day and all of a sudden it becomes an opportunity to try to save another bill, and we may end up trying to save another bill and kill them both before we're done with this. This is not the way the House Judiciary Committee ought to make law, in my opinion.
Committee, I will just make let you know one thing, that when someone is on the offender registration list and they move, they have to notify the authorities within 3 business days. Or I think it's if they buy a new car. There's several things that they must do and it gives them 3 business days to do that. So just keep that piece of information in your mind too as you're thinking about this. Representative Williams.
Thank you, Madam Chair. And to the carrier of the amendment, I think I like this piece of legislation, and I do think, just to note, when we do work House Bill 2173, whenever that time does come, I would like to see the language added with school property and city parks. Thank you.
Any other discussion on the amendment committee? Representative Carmichael.
It's one thing when a person is being sentenced, if the judge tells them you're going to have to be on the registry and you're going to have to register within X number of days, and whenever you buy a car or a jet ski or whatever it is, you got 3 days to register. But to take somebody who's been leading a normal life and to expect them to somehow know that we've now changed the terms of their registration without them being notified, they think they're complying with the law, to then say, you've got a week from the effective date of this law to quote unquote notify law enforcement. You know, on the corrections committee, I don't know if it was this year, it may have been last year or certainly in years before, we heard terrible stories about people who forgot to register their new jet ski in every county in which they worked, lived, went to school, and they ended up with another felony conviction. I really don't think that this is a good idea to, in what is in essence, pass a post facto law, which you may be able to do because it's a civil. Being on the registry is not criminal sanction, it's a civil matter. But to pass an ex post facto law that says we don't care that you've been where you've been forever and a day, but you've only got a week to register, I understand that it's a legitimate thing for us to discuss whether or not registered sex offenders should or should not be allowed to live adjacent to a school. But it's not something that you do after 5 o'clock, now after 6 o'clock on the last day of committee hearings. It's an opportunity to make terrible mistakes. And if the proponents of this idea go to leadership and say, here's what we want to do. We want you to hear but 2173, I think it is, if I remember correctly. 2173 on the floor, and we've got an amendment for it, then that's the closest thing to what due process requires. But to do this under these circumstances is not a good idea. Thank you.
Committee, do we have any other discussion on the amendment? Yep. Okay, so would you like to close on your amendment?
I'll close my amendment.
Okay, committee, you have heard the motion to amend House Bill 2404 with the Barrett amendment, and he's explained what it is. All those in favor say aye. Aye. Opposed, no. The amendment passes, and that language will be added into House Bill 2404. Okay, committee, now we're going to vote on, well, are there any other amendments? We're going to vote on House Bill 2404. Representative Williams.
I have an amendment. I'm just kidding. I'm just kidding. I move that we pass out House Bill 2404 as amended favorably for passage. As amended.
Do we have a second? Representative Osmond seconds. Wow. Okay, discussion on House Bill 2404. Representative Carmichael.
You know, we made good progress here over the last hour or so on 2404. We actually took it from a bill that I was absolutely not going to vote for, and we turned it into a bill that really had promise. But when we added the Barrett Amendment, It's impossible for me to agree to do something like that under these circumstances, and so accordingly, this is a bad bundle, and I will be voting against it.
Any other discussion on House Bill 2404? Seeing none, Representative, would you like to close?
I close and move my motion.
Committee, you have heard the motion to pass House Bill 2404 as amended, favorably for passage. All those in favor say aye. Opposed, no. Representative Carmichael would like his no vote recorded. That House Bill 2404 is passed favorably for passage. Okay, committee, that's all of our business. I do have a gift for everybody. After today, I feel like it should have been a way better gift. So you may take one of these and pass it. Everyone is getting one of these number puzzles. And I didn't do it when we started because I was afraid you would start working them while we were in committee. But you know, I just was thinking we have solved so many puzzles this year. I'm thinking of the scrap metal bill. I'm thinking of the third party, whatever that was. You know, this bill, so many things that we have worked together. We've seen Representative Carmichael and Representative Lewis, others work together. And I just really appreciate all you've done. I feel like we have solved a lot of puzzles. Thank you so much for your work this session in the House Judiciary Committee. Really appreciate everyone. And I have these. I feel like Jason's puzzle should be like this big because he did so many different maneuvers for all of us with amendments. I thank him for that. Committee, is there anything else that you have for the good of the committee other than Representative Lewis owes us like a lot of treats? Okay, Lene would like to say something to the committee.
I just want to thank the committee personally for letting me be with you, educating me on a lot of things. This has been really great. So thank you so much for having me.
And you've been amazing. Thank you to Lene. Okay, committee, anything else? All right, we are adjourned. Thank you.